36 minutes after 7 o'clock, changes could soon take effect to how much and for how long someone pays alimony here in the state of Florida. The state legislature has passed a bill described as contentious that not only impacts the amount of money a spouse receives from his or her ex, but also calls for a requirement from judges about how children in divorced homes split their time. The governor has 14 days to sign it, veto it, or send it back to the legislature. If he does nothing, it could take effect as soon as July 1st. Jonathan Zisser is a local family law attorney and joins us live via Zoom. Good morning. Thanks for being with us.
Good morning. How are you?
So there is a lot in this bill, as you know. There are 3 changes that could arguably impact couples the most if they divorce, which is why I'd like to start with those. So first, permanent alimony would essentially go away if this bill is adopted. Would you explain how it's awarded now and the significance of this change?
Sure. So it's a really significant change because in long-term marriages, meaning marriages of at least 17 years, a judge has the authority to award permanent alimony to a spouse, largely in situations where, spouses meet, 25 years ago, they're in the same place economically. Fast forward 25 years in the future, one spouse has been very successful while the other spouse has stayed home, raised the family, taken care of the children, put them into college, and has never, forwarded their own career. And that's under Florida law, that is a permanent alimony case. And with this change, permanent alimony would go away. So that's very substantial for families.
And currently they look at about 17 years of marriage or longer as permanent. So if this becomes law, would this be retroactive?
Unfortunately, the way this bill is written, it would be retroactive. That is a huge problem. And that is why the Florida Bar section, the family law section of the Florida Bar, and the American Academy of Matrimonial Lawyers is against this bill and has urged the governor to veto it. There's already a huge backlog of family law cases in the court system, and the retroactivity of this law would cause an incredible amount of strain in the court system because it would allow alimony payers to go back and immediately modify permanent alimony awards that have already been given, that have already been negotiated. In addition, it's really unfair to parties who negotiated in their own divorce permanent alimony. Maybe a spouse gave up something in order to get permanent alimony, and now that award could go away retroactively. It may even be an unconstitutional provision. And while alimony reform is inevitable, it should at least be prospective so that families have the ability to plan. Divorces are hard enough. Give families an opportunity to plan for it, not make it retroactive. That's a huge problem, and that's why the governor should veto this bill.
And so now there's another requirement also, this would be new, that would essentially require judges to begin with presumption that children should split their time equally between parents. Your reaction to that, and how would this change how it's done now?
Right. So another potential huge problem, because it's number one, it's not necessary. Parents already have equal footing in court. The standard right now is that when parents come into court, there is no presumption for or against either parent. The time sharing statute has 20 factors for a court to consider in order to determine what's in the best interest of the child. And every single family is different. Every family dynamic is different. Parents have different jobs. They live in different places. A statute that gives a presumption for 50-50 is essentially a one-size-fits-all, and that's just not reality. At this point, it puts an unfair burden on a parent to have to prove that 50-50 is not in the best interest of a child, as opposed to both parents coming into court and presenting evidence for or against their position. It's something that it's not necessary. It's going to be harmful. It's going to create actually more litigation. And another reason why we hope that the governor vetoes this bill.
And I know that part of your concern to this also is that in cases in which, a family member is accusing, that ex-spouse of abuse or anything else, to have to then have the presumption that that family member has to argue why the child should not spend 50-50 time with the spouse who's accused of abuse is really an issue here. Jonathan, there is so much to talk about with this. I hope you will come back in about 13 days, which is when the governor has the deadline, whether or not he makes a decision on this. And
Less
certainly
than
the
that.
law. Yeah, less because it's from the 17th.
July. Let's talk on July 1st and see what happens.
Will do. Thank you, Jonathan. Appreciate your time.